Dear august audience, we have with us a very much revered legal luminary with us today. Sir has held several prominent positions and delivered justice at various courts of India. We are honored to have with us the august presence of Justice Ujjal Bhuyan, Judge, Supreme Court of India. In March 2023, Sir made headlines when he expressed his intentions to constitute larger benches with more women judges in the Telangana High Court. And one of Sir's notable judgment in the V. Vasantamogli versus the State of Telangana, Chief Justice Bhuyan authored the judgment which struck down the colonial Telangana Eunuch Act 1919. Sir's remarkable achievements reflect his exceptional legal knowledge, integrity, and commitment to delivering justice. Sir, may I request you to kindly address the students and this august audience who have gathered here for the valedictory ceremony of Royal Lex Fiesta.
Respected Chancellor, Dr. Pansari, Honorable Justice B.P. Katakey, my former senior colleague in the Gauhati High Court, he has not changed much, except that his hair has become more grey now. Please excuse me, I wouldn't like to proceed further and take names because of a very not so good experience, that invariably when you take names, you will miss out on one or two. So to avoid that, it's better not to take names. All the distinguished guests who are present here, sitting and former judges of the Gauhati High Court, the chancellors of the universities who are present here, senior advocates of the Gauhati High Court, judicial officers, the large number of faculty from the different law colleges, advocates, distinguished ladies and gentlemen, and my dear law students. A very good morning to all of you. Just a couple of minutes left for 12 noon. It invariably happens to me, whenever I've given a slot in the morning session, it spills over into the afternoon session, and all my speeches which I prepare as with a good morning, I had to change it to a very good afternoon. But somehow it's still a couple of minutes left for 12. At the outset, I must congratulate our students who performed the beautiful Manipuri dance. It was a wonderful performance. I congratulate them. They have been able to express the beautiful essence of the Manipuri culture before us. I wish and pray that peace and stability returns to this beautiful state which has suffered so much for the last so many months. People say that Manipur is the jewel of India. People say it is the pearl of Asia. Some people even go to the extent of saying that Manipur is the heaven on earth. So we pray that peace returns to this beautiful land. We must all learn, there is a big lesson for all of us. We must all learn to live peacefully despite our differences in ethnicity, differences in language, differences in religion, and live peacefully, coexist peacefully, and in harmony. There is a big lesson for all of us. Every tragedy, every such incident has got a silver lining. And the only silver lining that I can draw upon this tragedy, unfolding and continuing tragedy, is that we must learn to live together. There's no other way for us to coexist and to move ahead. Friends, I'm very happy Chancellor, I have got my watch before me. I'll try and stick to the timeline given. I'm very happy to be present today for this valedictory function of the Royal Lakes Fiesta 2023, organized by the Royal School of Law and Administration, Royal Global University. I understand that students of various legal institutions of the Northeastern region have participated in this mega event. I congratulate the Royal Global University, particularly the Royal School of Law and Administration, in taking great pains in organizing this festival on such a grand scale. One of my very celebrated neighbors, he used to always say, Lakhadar Chaudhary, he used to always say that age, don't count your age. Age is just a number. Keep company of young people. I have tried to follow these words, his words of wisdom. Wherever I am, when I was a judge in the Gauhati High Court, I was closely associated with the National Law University and Judicial Academy, Assam. I had visited the Gauhati University Law Department. I had visited NEF Law College. I went to Tejpur Law College. Professor Bhuban Barua was the principal there. And I came to Royal Global University in 2017. And possibly I had inaugurated that moot court hall and also participated in a seminar on quality legal education and quality litigation. While at Mumbai, I had visited or I had participated in several moot court competitions in the famous Government Law College, Bombay, Mumbai. It is one of the earliest, it is the earliest law college in India and one of the torchbearers of legal education in India. I had also visited the G.J. Advani College of Law where I had participated. And while I was at Hyderabad, besides being the Chancellor of Nalsar, which is one of the prominent law universities in the country, I had visited and participated in several programs in the century-old Osmania University. Recently, my foray into the universities and educational institutions has given me a younger perspective to look at things. I always say and I always maintain that university is not a place of only higher learning. It is also a place for exchange of ideas amongst students. Young people, the bright young minds who are in the university campus like you are, have great ideas. Besides having undiluted fraternal feelings for your fellow students. You are full of energy and vibrancy. University is a place where new ideas and new thought processes germinate and find their full manifestation. Young students within the campuses are immune from the various ills plaguing the society. We have plenty of them, biases and prejudices. Therefore, I fully endorse the view that young minds should remain unfettered and should develop the habit of debate and discussion. You must have the habit of questioning. Questions on various issues which the society faces. Only if you ask questions, only if you debate, only if you discuss, you will find your answers, which are not there in the textbooks. So I therefore congratulate each and every participant who have assembled here to participate in this congregation of young minds. Winning and losing is immaterial, as Professor has said. Participation is more important. As you will enter the legal profession, every day you will argue your cases. Some cases you will win, some cases you will lose. You can't win all the cases. But your argument or your assistance to the court or the point of view that you argue, it is more important. The result is not in your hand. The result the court will decide, the judge will decide as per his thinking, as per his analysis of the law, evidence, and the facts of the case. Recently, Bar Council of India had organized a 2-day international seminar in Delhi concerning various facets of lawyering and legal education. I, along with Justice Srinivas Oak, my colleague from the Bombay High Court, who then became Chief Justice of the Karnataka High Court and now in the Supreme Court, we had moderated a panel discussion on the topic, Future of Legal Education, the Next Generation Lawyer, on September 24th. Amongst the panelists were Professor Dr. R. Venkata Rao, the former Vice Chancellor of National Law School of India, University, Bangalore, the present VC, Professor Sudhir Krishnaswamy, and Professor C. Rajkumar, the Vice Chancellor of OP Jindal Global University. From the discussions and deliberations, including from the inputs we got from the delegates, what was noticeable is that there is a clear demarcation in the quality of legal education in some of the law colleges or legal institutions in the country and the rest of the law colleges. We now have about 26 national law universities in the country. In addition to that, we have the traditional universities where law curriculum is imparted both at the undergraduate level, at a postgraduate level, also at the doctoral level. We have many law colleges, including government law colleges, and then in the private corporate sector, like we have here at the Royal Global University. According to the Bar Council, presently we have about 1,800 law colleges in the country. So when we have such a huge number of law colleges, certainly the disparity in legal education becomes apparent. While some of the elite institutions, some of the few institutions are now competing at the global level, majority of the law colleges are grappling with basic fundamental issues. We do not have adequate faculty or competent faculty to teach regular courses, civil procedure, evidence, criminal procedure, Indian Penal Code, so on and so forth. As Justice Katakey had said, that in the earlier days, people used to say, Jar nai goti, he kore ukaloti. We have come a long way from there. We have come a long way from there. When I studied law, we had an evening classes. And who were the students in the evening classes? Of course, there were some like me. I think I said this when I came here last time. Then we had government servants, retired government servants, planning to join law as a course. We had bored housewives who had nothing to do, therefore joined law. In fact, some of them became my good friends also. They offered me that, why don't you join our kitty? So at that time, of course, I didn't have much money. I didn't have that much of money to even join the kitty also. But somehow I did not join. So that's on the lighter side. But that was the composition of the law students who used to study law. And this is universally true throughout the country. The change came in 1985 when Professor Madhav Menon started this National Law School of India University in Bangalore. And if you look at the list of students, qualified students in the common entrance test, you will find they are the brightest of all students in the country with first preference for law. It is not that they go for IIT, they don't get IIT, they try for IIM, they go for medical, they don't get medical, therefore they go for law. It's not there. Their first preference is law. But again, this is also leading to the great divide in the country between some of the best law schools in the country and the other which are lagging behind. Therefore, I think there is a need and necessity for the leading law universities, law schools, to also carry on with them the other law schools, the other law colleges in the relevant areas. It is all like we have the corporate social responsibility. We can think about this. It's a part of your academic social responsibility also. While I was here, we were thinking that why not the National Law School should have bring within it, or why not we have an act like the State Law University Act. We have one in Karnataka where all the law colleges have been brought under one university, one act. So why don't we have an act, a state legislation, bringing all the law colleges under the one roof, and where the National Law University, which has got substantial backing from the state as well as from the judiciary, can have a helping hand to these universities. So these are the areas which we need to look into. As I said, there's a marked difference between legal education during our time and the legal education which we now have today. Migrating from part-time course to full-time course is one. Setting up of high-quality legal institution, including NLUs, with well-developed infrastructure. Marked improvement and diversification of the course curriculum. Establishing 5-year law course while continuing with the traditional 3-year system. Joining of large number of meritorious students opting for law as their first choice. These are certainly the plus points. On the flip side, we have noticed that there is a great disparity in the quality of education provided by some of the premier institutions and other law colleges. This disparity has arisen because of the meritorious students which these institutions attract, along with high quality faculty. On the other hand, many of the state level colleges and comparable institutions are somehow floating around with average to not so average intake of students and lack of quality and competent faculty. Not to speak of emerging subjects, even regular subjects are not having qualified teachers. To add to such lopsidedness, there is lack of adequate infrastructure in the second category of institutions. When I was the Chief Justice of Telangana High Court, by virtue of my office, I was also the the Chancellor of NALSA. On 25th, while I was there in September, Justice B.P. Jeevan Reddy, former judge of the Supreme Court of India, known for his judgments on the taxation law. Of course, many of those practicing on the taxation side will say he was too much of pro-revenue to the detriment of the SSCs. He had donated 1 crore of rupees for starting a Center for International Trade and Business Law in Nalsar. Nalsar has got several such centers. Recently, I was invited to speak on a conference organized by the Maharashtra National Law University at Mumbai on space and aviation law, on aviation and space law. So there, while participating in the seminar and in the exchange of ideas, I could notice where the legal curriculum is now traversing. It is no longer confined to conventional and traditional subjects. Of course, we must have the foundation, otherwise we'll be without any foundation, without evidence, without the procedural law, will not be able to reach very far. Nonetheless, why I'm saying this, that law has got very many emerging subjects, including, I think in NLU, Assam, we have the Center for Child Rights. I think when I was here, it was there. Center for Disability Rights is there. Now, post-Puttaswamy judgment with emerging women's rights, including the bodily autonomy of a woman and having a say on reproduction, is an area of study and research in India today. In January, I got an invitation from the Robotic Surgeons Association of India that please come, we are organizing one seminar in Goa, please come and address us. So I was, of course, destination being Goa, it was certainly very, very enticing, but I was wondering what, as a judge, I would say or what I would do in a conference of robotic surgeons. I did a little bit of research. Now, the robotic surgeons who practice robotic surgery, they say that robotic surgery has got a lot of advantages over the surgery which is practiced, presently being practiced, including laparoscopic surgery. They say that the robotic arm of a surgeon can reach any part of the human body, unlike a human surgeon. And unlike a human surgeon, a robot does not suffer from any fatigue. A human surgeon may get tired, but a robot does not. He can do as many surgeries as is possible. A surgeon sitting in Delhi can perform a robotic surgery in Gauhati. Of course, the robots that we have are all first generation robots. These are all computer programmed robots. We are yet to reach the stage of robots being driven by artificial intelligence, which is the second generation robots. Saudi Arabia has conferred citizenship on a robot. She is named Sophia. They have conferred citizenship. So I was wondering, and I discussed with the surgeons there, two things. One, what about conferring personhood on a robot? Maybe a surgical robot. What about conferring personhood on a robot? And in an event of the operation going wrong, liability will be on whom? Now, in law, we have two categories of persons, the natural persons and artificial persons. Natural persons, we all know. Artificial persons, we give by legal fiction, we confer personhood on such for the purpose of litigation, for the purpose of fastening legal liability, or sometimes conferring rights also. For example, a corporation or a company is an artificial person. The director may be an individual SSE, but the company as a whole would also be an SSE. Similarly, in Hindu law, we have the Hindu undivided family, HUF, which is an taxable entity. Likewise, a Hindu deity is a person, juristic person. So therefore, when a surgeon employs a robot to perform operation, he will attract patients to his clinic or hospital, not only by dint of his name and fame and his skills, but also because he has employed or he has used a robot to assist him in the performance of his surgery. So is not the robot entitled to a share of his income? I was posing that question to my friends, the surgeons' friends. And what about the liability? Suppose we have a lot of call drops in our mobile phones. Sometimes we go for video conferencing, sometimes we have a video chat, but suddenly, because of technology, there is a disconnect there. So suppose the surgeon sitting in, say, New York, conducts an operation in Hyderabad, and there is something, then there is a snap in the technology. What will happen to the patient? What will happen? Who will be responsible for that? Once there's another thing. If we now have the problem of hacking. If the program is hacked, because nowadays the robots are being operated by programming. If the program is hacked, and the robotic arm goes here and there, everywhere inside the tummy, what will happen? Who will take the responsibility? So they said, Hari, we did not think about all these things. We were only busy about operations, and they did not say about the balance, the check payments. But these are questions which are staring at the face. More so, because now, as per the American Medical Journal, we are expecting a first robotic doctor, not a surgeon, a doctor by 2035. As of now, the robotic doctor or the robot can read your parameters, your body parameters. This is the BP, this is your sugar level, this is your thyroid profile, like that. So we are expecting by 2035 a robotic doctor. So along with this, all these issues, legal issues will crop up. We need to rise to that level. Technology has become an important part of the judicial system. While I was the Chief Justice in the Telangana High Court, we started the live streaming of court proceedings. Live streaming, in fact, there is a judgment of the Supreme Court. A litigant has a right to know what is going on in the court, what has happened to his case. He has a right to know. It is not enough that we tell him that, all right, today you have filed a case, now you disappear, you come after 5 years. Or in between, when I need your fees, you come then. It's not that. A litigant has a right to know within how much time my case will be decided. And we as a system must be able to provide that answer. The answer need not be with mathematical precision, that yes, your case will be decided in 2 years, 4 months, 13 days. No. But we should be in a position to tell the client, the person who comes to the court seeking justice, that yes, your case will be decided within a reasonable time frame. That we must be able to be in a position to say. We have come across many instances in the past when we hear lawyers and judges saying, all right, you tell me the date, I will give you the years. In today's context, it is not acceptable. If we say that, we have failed as a system. Justice Katakey had raised the issue of huge pendency of criminal cases. It is true. This is a process which is accumulated over the years. We can't blame the present generation of lawyers. We can't blame Anshuman Bora for that, or we can't blame Dr. Saraf for that, or Chaudhary for that, or Mr. Sahibullah for that. This is accumulated over the years. Now what to do? And in criminal cases, of course, petty cases can be compounded. We have in our criminal procedure code provisions for compounding. Compounding means for compromise. We also have provisions for plea bargaining, though not properly utilized in our context. But civil cases are also huge in number. He has rightly pointed out that in many states, including our state, we have seen a declining trend in civil cases corresponding to lodging of criminal cases. One reason is this, that people are converting civil disputes into criminal disputes for an early resolution or a more effective resolution. This could be one area. Or that the civil lawyers or the civil lawyering is slowly fading away from our courts. But this is not so in South India. From my experience in Telangana and now as a judge in the Supreme Court, we see a continuous flow of cases from Tamil Nadu, particularly from the benches, Madurai bench, Kalburgi bench of Karnataka High Court, so many civil cases coming. So therefore, and I am told that on a ratio of 10 cases, 6 will be civil cases, 4 only will be criminal cases. This may indicate something else also, the general affluence of the people, comparative affluence of the people, more effectiveness of the legal system there, or maybe more effective the administration there. Maybe, I do not know. We need to have a deeper study there. But having more criminal cases in comparison to civil cases is certainly not a good sign for a society. The Chancellor has spoken about false FIRs. These cases are coming. The recent trend, I had come and I addressed the chartered accountants, a conference of chartered accountants. Of course, this is a trend from the past, but recently it has become more pronounced after coming into of the GST legislations, that even before quantification of the GST due or the amount which is due, provisions of section 69 of the CGST Act, which is a power to arrest, is resorted to. And many people are arrested. And under coercion, they are forced to pay a huge amount of money. Even before, what is the due you have to pay is quantified. So in one matter, Daulat Samirmal Mehta versus State of Maharashtra, my bench, I along with Justice, Madhav Jamdar, we had in Article 226, in a petition under Article 226, we had granted bail. We said that you can't do this. When if you find, and you will find that in the appeal provision, after the amount is quantified, if an appeal is filed, you pay 10% of the amount due, there is automatic stay. If this be the position, then saying that, oh, you have not paid this amount of 1 crore rupees or 10 crore rupees, therefore you are putting you behind bars, is certainly, in my view, a very arbitrary exercise of power, and we had exercised that power in Bombay High Court. But to be on the safer side, we found that all the high courts in the country, starting from Telangana High Court at that point of time to Calcutta High Court, barring 1 or 2 cases from Delhi High Court, had rejected the prayers for bail or anticipatory bail. So to be on the safer side, we put 2 conditions, that all right, you will be released provided you deposit 5 crores, and after 1 month you will deposit another 15 crores or 20 crores, something like that. When this was challenged by the GST Commissioner before the Supreme Court, the bench headed by Justice Rohinton Nariman, they stayed the 2 conditions, refused to decline to interfere with the order passed under 226, but stayed the 2 conditions. So we felt very vindicated on this. So as the Chancellor has pointed out, every now and then, on a drop of a hat, we have the tendency to lodge an FIR, to file a criminal complaint. And the recent trend is not only to file in one place, to file the complaints all over the country. It's a kind of an harassment. The matters are there in the Supreme Court. I am also part of the bench, so I will not say anything beyond this, that this is a live issue the country is facing. Criminalization of the society. Normal human beings pursuing the normal activities, speaking normal language, which is permitted by the Constitution, normal dissent, normal disagreements are being criminalized. This is not, I think this is contrary to what our Constitution says. As students of law, as budding lawyers, we all must have abiding faith in our Constitution. As Justice Katakey has very rightly said, if you ask me that which is in one sentence, what will you say is the essence of the Constitution? I had asked my law clerks, I told them that I'm going to Gauhati to address this Royal Global University. Please give me your assessment. What, according to you, are the important articles of the Constitution? One said, preamble to the Constitution of India. Certainly it is. Another said 14. Then he said, no, 19. Then he said, no, 21. Finally he said, no, 14, 19, 21 together. Then another said, no, 368 is the most important article. I said, why 368? Because 368 deals with amendment of the Constitution, and Supreme Court, by its interpretation of this article, 368, notably in the famous Constitution judgment, is one of the foremost constitutional cases of India. A bench of 13 judges, I spoke about this when I visited the National Law University, Gauhati, in the last occasion. By a majority of 7:6 in Keshwananda Bharati, held that Parliament has all the powers to amend the Constitution. They can amend the Constitution. But in the process of amendment, you cannot alter the basic structure or the basic features of the Constitution. This is the law of the land. It was severely criticized at that point of time that it is anti-democratic. Judges who are unelected, who are not responsible to the people, have laid down this proposition that you cannot amend the basic structure of the Constitution. Power of Parliament should remain unfettered. This was the view expressed, and the view continues till date. There are various proponents who have raised question mark on this. Even the two great personalities, one who has already attended here and one who would be coming here, they have raised questions about this. But as a student of law, I can only say that this is the law of the land. This principle of law, that you cannot amend the basic structure of the Constitution, is by a bench of 13 judges, the largest ever bench in our country. This judgment has thereafter been followed in at least 10 constitution benches, including 7 judges bench in that Coelho case, 9 judges bench in the Nagaraj case, Vaman Rao, the Minerva Mills, so on and so forth. So therefore, this is a law which is said that this constitutional law has been engraved on stone. It cannot be changed. There are many critics. He says law cannot be engraved in stone. Law should always be flexible, dynamic. But there are fundamentals of our law which cannot be changed and which should not be changed. This is one. Otherwise, we no longer have the Constitution that we have. Going back to the question, that which, in your opinion, one line, if you want to say, what is the essence of our Constitution? I would say, the essence of our Constitution is equality. Equality between men and men, equality between men and women. This is in one line if you say, this is the essence of our Constitution, and all the provisions collectively would aid and assist this principal presumption of equality. Democracy is a basic feature of the Constitution flowing from Keshavananda Bharati. Dr. Ambedkar had said, or he had defined democracy or a democratic way of life as respect for fellow human beings, reverence for fellow human beings. Don't discriminate on the basis of caste, religion, language, community, ethnicity. It is so very relevant till today. It is very relevant. Justice Katakey had referred to the poverty line, people below the poverty line, 33%. Even now questions are raised about who has drawn that poverty line. If a more rational, realistic assessment is taken, if a more realistic poverty line is drawn, well, 33% can be much more than that. So therefore, we are, so this is the position. I don't want to, being a sitting judge, I have my own limitations, I don't want to say many things, but this is the position which has emerged today. Friends, the young students, I'm sure you will do very well in life. Just before I wind up, I would like to address my young students. Law is not rocket science. It is not a rocket science. But law requires dedication, hard work, and sincerity. And you have to burn the proverbial midnight oil. Though I don't like this expression at all, but it is said that law is like a jealous mistress. You have to give her full attention. You have to give her full commitment. When you enter the profession of law, you must be prepared for a long innings. It is not 2020 cricket. It is not even one-day cricket. It is test match. You must have the technique to face spin bowling. You must have the technique to face bouncers, fast bowling, and play it out. Don't go for glamour. Law is not only in the high courts or in the Supreme Court. Barring the 3 chartered high courts, Calcutta, Bombay, and Madras, and Delhi, other high courts in India have very limited original jurisdiction. We do not have the jurisdiction to try civil suits. So, if you ask me that what should I do as a lawyer since I am joining the law, my advice will be your initial years should be devoted to trial court advocacy. Majority of India's litigation are fought in the trial courts. This is the jurisdiction where you will learn the law relating to procedure, evidence, and taxation. Substance. While I was a judge in the Bombay High Court, one of our law magazines, SCC Online, they wanted to interview me. Normally, judges should not give interviews. Of course, we now have very many aberrations. One sitting judge of Calcutta High Court gave an interview on a litigation pending before his court. Of course, the Supreme Court had to intervene in that. The interviewer had asked me, "Do you have any regrets in life?" I said, "I have no regrets." At that point of time, while I was in Bombay, COVID was there. I said, "No, I have no regrets. Being a lawyer itself is a great opportunity to serve justice. To be a judge and to deliver justice is a God-given opportunity." Looking back now, the time I left Gauhati on 1st October 2019 to now, life has turned a full circle. There's no regrets at all. There can't be any regrets. Then she asked me that given an opportunity, is there anything which I would like to do again? Is there anything which I had missed out and I would like to do again? To this question, my answer was that if I am given an opportunity to rewind my life, professional life, I would devote more time to trial court advocacy. This is one area where I had missed out. I would like to do that. Then she asked me, can I take 2 more minutes? Then she asked me about the independence of the judiciary. Since I am here, I will touch upon it, though I will try to avoid any complexities and controversies. She asked me, what about independence of the judiciary? Whether judiciary can withstand administrative and political pressures. I told her that Indian judiciary has been built literally brick by brick by great men and women. There may be aberrations here and there, it is bound to be there. 34 judges in the Supreme Court, we have 34 people, and with sitting in benches, there are bound to be divergence of views. But overall, and I had addressed this at the Bar Association meeting also, I said this, great men and women have contributed over the years and built up the edifice of our Indian judiciary. It cannot be destroyed by individual acts of aberrations or judicial aberrations here and there. Judicial aberrations we have seen. Our court is fully capable of rectifying it. One instance, recent instance, we don't need to go back to Gopalan and then Menka Gandhi or R.C. Cooper. One instance. Delhi High Court in Naj Foundation had struck down Section 377 of the IPC, saying that in a case of 2 consenting adults, maybe of the same sex, 377 cannot be invoked. In Swaraj Kaushal, a 2-judge bench of the Supreme Court set aside this order, saying that no, this is for the, firstly they said it is for the Parliament to decide whether 377 should be outlawed or not. It is for the Parliament to decide. Finally they said, we are also persuaded in taking this view because it is only a minuscule percentage of population which can form the part of the LGBTQ community. And therefore we should not be unduly perturbed about all these issues. These are all foreign issues. We should not be. In Navtej Singh Johar, 4 years thereafter, 2014, 2018, 4 years thereafter, the bench overruled the same decision in Swaraj Kaushal and struck down 377 between consenting adults. Supreme Court has said through the opinion of Justice Chandrachud, as he then was, that Supreme Court is not guided by majoritarian concepts. As an institution, Supreme Court or the judiciary has to take a contrarian view, anti-majoritarian view. It has to take. We are not guided that because majority of the people think it this way, therefore we have to uphold this. This is not the job of the Supreme Court. This is not the legal position. Therefore, I would say that Indian Supreme Court, or for that matter, Indian judiciary, we face a lot of problems, no doubt about it. Still, people have faith in the judiciary. Mind you, we in the judiciary, we do not have the purse or the sword. We neither have the purse nor the sword. All that we have is the confidence of the people. Our strength is the confidence of the people, and I can say, vast majority of our people still repose confidence in the judiciary. And all those judicial officers who are present, all the lawyers who are present here, we should always keep this in mind, that confidence of the people will be breached if the right-thinking person goes away from the court thinking that either the judge was biased or he was not given a hearing. So these are the principles we should always keep in mind. Judiciary, it is in the interest of everybody to have a strong, vibrant and independent judiciary. A country's standing in the international community will be measured whether it has got an independent judiciary or not. India's judiciary has stood the test of time. I'm sure it will continue to make us proud. My young friends, I wish you the very best in life. I'm sure all of you will be successful in whatever avocations you take. Many of you will become good lawyers. Some of you may join the academia. Some of you may join the corporates. Some of you may become politicians. Yeah, we need good politicians. And who else? Students of law or lawyers can become good politicians, ministers and MLAs. Macaulay, the brain behind India's IPC, went back to England and became a member of parliament and participated in lawmaking. So I'm sure all of you will be successful. In due course of time, some of you may become judges also. And I will be very happy if one amongst you can become the Chief Justice of the Telangana High Court, where I was. My thanks to the organizers for inviting me here to speak a few words and interact with all of you. With these few words, I thank each one of you for coming here and be a part of these proceedings. Thank you very much, and God bless.